Let me
Turn that back around.
All right, I hit the gavel. So, welcome to the Town of Durham, New Hampshire's annual Right to Know Law Forum. I'm Todd in Durham, and I am joined this evening by our legal counsel, Laura Spector-Morgan.
Good evening, everyone.
And Laura is going to walk us through the highlights of the state's Right to Know law. Our goal is for folks who have questions to be here and ask questions and learn. And we do record this so that members of our boards and committees and commissions or members of the public can watch this at a later date on demand on DCAT. So Laura, please take it away.
Good evening, everyone, again. And there is also a handout here for those who are here in person. There will be extra copies for those who want to pick one up from Todd. And I don't know if you might put it on the website as well.
Yes.
That might be helpful too.
Yes, I think we will do that. That's great.
Okay, good. So we're going to run through 91A in its entirety, and I can tell you there was only one amendment for 2024, and it's really sort of a part common sense, part technical amendment, so we'll talk about it when we get to that part. But the Right to Know law is broken down basically into two parts. There's a part that covers the requirements for meetings, and then there's a part that requires disclosure of documents, and we sort of talk about them in two different parts. And for most board members, the part that's really applicable is the part about meetings, because the document part is really generally handled by staff. So we're going to start in the preamble, because that's where the court always starts. And the court really focuses on the language in the preamble, which is that openness in the conduct of public is essential to a democratic society. The purpose of this chapter is to ensure both the greatest possible public access to the actions, discussions, and records of all public bodies and their accountability to the people. So when the court reviews Right to Know law cases, they really focus on that, and their goal is to ensure that the people have the most access to their government and that government is acting in a transparent manner. And if the request that is being made does not further that purpose, even though it might be a request made for a good reason, the court is not going to spend a lot of time enforcing that request. But if the request does further that purpose, there's going to be a very heavy burden on the municipality to demonstrate that whatever the municipality is not disclosing or is doing in non-public is properly being withheld or is being done in non-public. So that is the overarching goal of the Right to Know law. It applies to all public bodies, and public bodies for the purposes of towns are all legislative bodies, and in Durham that means your town council as a general rule, though you do occasionally have a town meeting. Your governing body, again, your town council, any board, commission, committee, agency, or authority, and any advisory committee. And an advisory committee is a body that is established by one of those other boards, commissions, committees, governing bodies, whose primary purpose is issues designated by an appointing authority, so as to provide that authority with advice or recommendations concerning the formulation of any public policy. So before we began tonight, Todd and I were talking about what happens if less than a quorum of a committee gets together to talk about something within that committee's jurisdiction. And as long as we're not talking about a land use board or a quasi-judicial board, as a general rule, if less than a quorum of members get together to discuss an issue that is within a board's jurisdiction, that is not a violation of the Right to Know law. That doesn't necessarily mean it's a good idea, but it's not a violation of the Right to Know law. And that is but if the committee is appointed, so if you have your Conservation Commission and it appoints 3 members to go off and write a policy, that is an official advisory committee, and that committee does have to comply with the Right to Know law. So we have ones that are officially created by a board, they have to comply, And then we have 2 or 3 people who just get together to talk about things, and they have no official role, and they don't have to comply. So that's the distinction there. So meetings, all meetings have to be open to the public, and meeting is a gathering of a quorum of a board, and a quorum is, of course, a majority unless the rules of the board define a quorum otherwise. And a meeting means whenever a quorum of the board gathers to discuss a matter over which that board or commission or committee has jurisdiction, where the members of that board, I'm just going to use board as shorthand, are able to communicate contemporaneously. So obviously, when you all gather in a room, that is a meeting. If you were all to be on a conference call and you could all talk to each other, that is a meeting. If you are all on a video call, that is a meeting. If you are all on an email chain where everyone is CC'd, that is a meeting. And chances are excellent it's an illegal one. Please, please, please do not email each other about anything over which you have jurisdiction. We'll talk more about email in detail in a little bit, but that is the general definition of a meeting. Now, if you all happen to find yourselves at a cocktail party and you are sipping champagne and talking about the weather, that is not a meeting, because you're not discussing anything over which the board has jurisdiction, and it happens to be a chance social encounter. That's completely fine. Just don't pull yourselves all into a corner and start talking about something over which you do have jurisdiction. That's a problem. Other things that are not a meeting are collective bargaining meetings, consultation with legal caucuses of political bodies, and circulation of draft documents, which, when finalized, are intended to formalize decisions previously made in a meeting. So if you are the planning board and you have made a decision and Michael circulates a draft notice of decision for you to review and comment on, and you do that, that is not a meeting. However, that document that has been circulated is a public document that will be subject to disclosure under the right to know law. So you can have the email conversation about it, but the document and the emails will be subject to disclosure. All meetings have to be open to the public. No vote can be taken by secret ballot. All votes have to be taken at a public meeting and by orally. Any person is permitted to record your meeting, and they can do that with a video recorder on their phones, an audio recorder, however they would like to do that. Minutes of all meetings have to be kept, and those minutes can be very, very brief. All they have to include who are in attendance, the persons appearing before the bodies. I like a list of all persons who are in the room. Technically, it just has to be the persons who are speaking, and a brief discussion of the subject matter discussed and any final decisions that are made. The names of the members who make and second motions also have to be identified in the minutes. So really, the minutes can be very brief, and I think I tell this story every year. The Town of Hanover Zoning Board of Adjustment, you can summarize their meeting minutes in 2 pages because they literally include the name of the board members, the people who spoke, and the motions that were made. Because they have decided someone has to decide what's important at a meeting, and it's not going to be the person who gets paid $10 an hour to take minutes. So whenever we have an appeal from one of their decisions, we have transcripts made, and it costs them a fortune in the appeal process. But we have an excellent record in the appeal process when we do that. So minutes really can be very sparse. And when we talk about non-public sessions, that is exactly the kind of minutes you should have coming out of. Those minutes need to be made available to the public within 5 business days. And I often hear boards say, well, there's no way we can approve minutes within 5 business days. And chances are pretty good that no, they're not going to be approved within 5 business days. There's actually no requirement under the right to know law that you approve minutes at all. Your draft minutes need to be available within 5 business days. And you can have a big draft stamp all across them. You make them available to the public. You can change them when you approve them. And then when they're approved, you can take the word draft off. You can put approved at such and such a meeting. and those are your final minutes. Those minutes become permanent records of the town, and they have to be kept forever. Notice of all meetings has to be given at least 24 hours ahead of time, and that 24 hours excludes Sundays and legal holidays. And it has to be posted in 2 appropriate places. One of those places can be the town's website, or it has to be printed in a newspaper of general circulation. As you can imagine, almost no one does that because A, no one reads newspapers anymore, and B, it's expensive. You don't have to give 24 hours notice in an emergency. And an emergency is defined as a situation where immediate, undelayed action is deemed to be imperative by the chairman of the public body. So, for example, you have a water leak in the town offices, and someone needs to decide what to do immediately. It is fine for the town council to gather and have that conversation on less than 24 hours notice. What you have to do in that situation is the presiding officer or whoever needs to post as much notice as you possibly can and take whatever means possible to give notice to the public. So you would post it on your website, you would perhaps contact the local radio station. If you have a system by which you send out emails or texts, you would do that. If you do tweets or whatever we call them on X now, you would send those out and you would notify the public that you're having this meeting. In addition, in the minutes, you have to spell out exactly what the emergency was. And that's really all you need to do in that emergency situation. So, absent an emergency, and they're few and far between, 24 hours notice is the rule. Now, if a member of the public body believes that whatever discussion is happening at the meeting is inappropriate or violates the right to know law, that member can object to the discussion. And if the conversation continues and that member is uncomfortable, that member can say, I want my objection noted in the minutes. And their objection then shall be noted in the minutes. If it happens that the member is objecting to whatever's happening in non-public session, that member's objection gets noted in the non-public session minutes and then also in the public session minutes, though the notation in the public session minutes is truncated, so that it's just the member's name, a statement that they objected to the discussion in non-public, and a reference to the provision of 91A32 that was the basis for that discussion. The legislature has periodically updated 91A to try to keep up with technology. We'll talk about that with the 2024 amendment, but one of the amendments they made relatively recently has to do with towns who have internet websites, which of course Durham does. So because you have a website, you have to post your approved minutes in a consistent and reasonably accessible location on the website, or on the website you have to post and maintain a notice stating where the minutes can be reviewed and copies requested. Additionally, you have to post meeting notices on the website in a consistent and reasonably accessible location, or you have to post and maintain on the website a notice stating where the notices are posted. So obviously it's just as easy to post the notices as it is to post the notice saying where the notices are. You're also allowed as a public body to allow one or more members to participate electronically. A lot of board members go to Florida for the winter, or since COVID, people are much more sensitive to coming to meetings when they're not feeling well. And since COVID, we also luckily have much better technology to allow people to participate electronically. So it's an option, it's not a mandate, it is entirely up to the board itself. And the board can decide to allow that to happen, and they can also change their mind and decide they're not going to continue to let it happen. If they decide that it's going to happen, you have to have a quorum of the board physically present in the location of the meeting, and each part of the meeting that is supposed to be open to the public, and whoever is participating electronically has to be able to hear and participate in the entire meeting, and whoever is sitting in the public has to be able to hear and communicate contemporaneously with the member who is participating electronically. Specifically says, no meeting shall be conducted by electronic mail or any form of communication that does not permit the public to hear, read, or otherwise discern the meeting discussion contemporaneously. Whoever is not physically in the room needs to identify why they're not there, why they cannot be there, and anyone else who is with them wherever they are in the room. But they are deemed a full member for purposes of voting. They can absolutely participate in votes, and all votes at those meetings have to take place by roll call. So I know some boards just routinely do all votes by roll call. You don't have to do that, but if you have a member participating electronically, you do have to do it by roll call. Now, unless you fall into a non-public session, no discussion of any matter over which you have jurisdiction outside of a publicly noticed open to the public meeting. The statute uses the word deliberate. Public bodies shall deliberate on matters over which they have supervision only in meetings. Deliberate means discuss. Do not discuss anything over which you have jurisdiction if you are a quorum, unless you are in a publicly noticed meeting. And we'll get to the penalties towards the end of the session. Any questions so far? I don't have any access to anyone on Zoom, so I don't know if there's any questions.
Rachel, is there anyone on Zoom who has a question at this point?
No questions. We have one person on Zoom.
Okay.
Okay.
Let's talk a little bit about non-public sessions. Non-public sessions really pertain mostly to your town council. Most other boards probably don't have a real reason to go into non-public session, but I think the less often you do it, the trickier it is. So let's go through them. You can go into non-public session, which is a session where you kick the public out of the room and you just have the board members for very specific reasons. And you have to do it in a very specific way. There has to be a motion to enter non-public session, and you have to identify which section of 91A32 you are going into non-public session under. And the vote to go into non-public session has to be a roll call vote, and you have to identify in the public minutes as you go into non-public session who voted to go in and who voted not to. And I see boards cheat this a lot. I see them just take a vote and the secretary's like, oh, I'll just write it down as a roll call vote. Take the roll call vote. It takes a minute. Just take the vote. Only the following matters can be acted on in non-public session. And you have to identify, you can't talk about anything that you don't identify in the motion to go in. So if you go in for one reason, and while you're in there, you realize you have another topic to talk about, if you haven't identified that in the motion, you have to come out of non-public session, have another motion to go in, go back in, talk about that topic, and then come back out. But if you know ahead of time that you want to talk about 2 or 3 things, you can make them and say, we're going to go in to talk about this, this, and this. So that's fine, as long as you know ahead of time you're going to do that. So you can go in to talk about the dismissal, promotion, or compensation of any public employee or disciplining any employee. The trick here is that if that employee has a right to a meeting and requests that that meeting be open, it has to be held in public. And most employees, if they have a right to a meeting, also have a right to be held. So you have to tell them before you're going to hold the meeting so they know that they have the right to ask for it in public. And if they want it in public, you have it in public. Frankly, the reason you're having it in non-public is to protect them. So if they want to waive that, they get to waive that. Hiring of any public employee can be done in non-public. Matters which, if discussed in public, would likely adversely affect the reputation of any person unless that person is a member of the board and unless that person requests an open meeting. Here, there's a little twist. That person can request an open meeting, but there's a case that says you don't have to give them notice you're going to talk about them. So you can go into non-public session and talk about them. You don't have to tell them you're going to talk about them, so they don't necessarily know you're going to talk about them to ask for an open meeting. You can go into non-public session to talk about buying, selling, or leasing real estate if talking about that in public might give someone else an unfair advantage against the town. So if you've got a property owner who has come to the town and said, look, I'm getting ready to sell my property. I'd really like to sell it to the town, and I'd like to give it to you at a really good price because I want to see it used for a town purpose. You can talk about that in non-public sessions so that all the developers don't hear about it and go to that person and say, I'll double that price if you'll sell it to me. That's completely fine to do in non-public session. You can talk about any pending claims of litigation that have actually been filed or threatened in writing. And you can do that until the claim of litigation has been fully adjudicated or settled. But an application filed for tax abatement doesn't become litigation until the appeal is actually filed at the BTLA or Superior Court. Then there's a whole bunch of them that don't apply to towns. There's a couple that apply to school boards, so I'm just going to walk through those real quick. School boards can go into non-public session to talk about a pupil tuition contract authorized by RSA 194 or 195A, which, if discussed, to benefit a party or parties whose interests are adverse to those of the general public. I don't do school law. I don't know what that means, but those of you who do, you can go into non-public session to talk about legal advice that was provided by counsel. Even if counsel isn't there, this actually arises out of a case as well. If your town attorney writes you a letter, sends you an email, has a conversation with a staff member, you can go into non-public session to discuss that advice, even if the attorney is not there. And then, this is a new one. You can go into non-public session to talk about releasing old sealed minutes of non-public sessions, because the legislature now requires boards to go back and review all your old sealed minutes of non-public sessions to decide whether or not there's still a reason to keep them sealed. I think best practice has always been to do that. It has never been a mandate, and it's sort of an overwhelming thing to think about doing, so I don't think very many towns have done it, but now we have to do it. And we'll get to that sort of at the end, because let's talk first about how minutes can be sealed. And they don't call it sealing anymore. They call it withholding them. So minutes of non-public sessions have to be kept in the same manner as minutes of regular meetings. So they can be just as sparse. Board members briefed of what's discussed and a record of votes that were taken. And they have to be disclosed within 72 hours. And as a general rule, I encourage non-public minutes to be pretty sparse. We went into non-public session to discuss legal advice we were given. If you do that, there's absolutely no reason to withhold those minutes. Just release them to the public. Then you never have to worry about going back and unsealing them. They're just out there. And they don't disclose anything that you actually talked about. But if you can't do that, or if you need your minutes to be more detailed, you can withhold them from the public by a vote of 2/3 of the members if it's determined that divulgence of the information in the minutes would likely adversely affect the reputation of any person other than a member of the body itself, or would render the proposed action ineffective or pertain to terrorism. So if you're discussing plans, safety plans to protect the town in the event of a terrorist event, you can keep those sealed. So they can stay sealed or withheld until the reason for keeping them withheld no longer exists. And specifically in the statute, the legislature talks about withholding minutes that relate to the real estate negotiations that we talked about back in the reason to go into non-public session. And they say that as soon as that sale is closed or abandoned, you need to release those minutes. And what it said is towns can, and really should, set up a process for going through and reviewing all of your old sealed non-public minutes on a regular basis and determining when they can be released. And if you don't do that, they're automatically released after 10 years. And you further have to keep like an index of all your sealed minutes. And it's got to identify the date of the meeting, the board, and the exception under which they went into non-public session. And I think the date when it was last considered whether or not to release them. So it's again, furthering that gender and transparency. And it's a relatively new thing, but I think most of our towns have gotten on board and pretty much have that well in hand at this point. I'd imagine you guys do.
Yeah, we are, we've gone back to find all of the dating back like 25 years.
Yeah.
And we're slowly marching through them year by year and bringing them to the council to unseal. And so far, we've not yet found a set that needs to remain sealed.
Wow.
Or, what's the word?
Withheld.
Withheld.
That's amazing.
So it's slowly taking place.
Good, that's great. So that's non-public sessions and non-public minutes. So then we get to, that's everything about meetings. Now we're going to start talking about documents, unless there's questions. And I assume someone would tell me if there was a question. So 91A4 starts talking about minutes and records available for public inspection. And what it says is that every citizen during the regular business hours of the town, on the regular business premises of the town, has the right to inspect all governmental records in the possession and control of the town and to copy them or make memos of them. And you'll note that you don't get those kind of requests very often. The requests you get are, please copy and send me all of the minutes from the town council from the years 1984 to 1986. And let me know how much it's going to cost, and I'll send you a check. If it's going to be more than $100, tell me ahead of time, because I don't want to pay more than $100. And if they're available by email, please email them to me. You don't have to do any of that. You can say, thank you very much. We keep those minutes in a binder in our office, and you are free to come review them at your leisure, and you can make copies of them while you're here. And by the way, we don't provide a copy machine. Bring your cell phone, you can take pictures. Most towns don't do that because, frankly, having those people in your office, taking the copies and emailing them to them, but you have the right to do that.
And Laura, what we often will do is simply direct people to our website.
Yes.
Where they can find them themselves.
Yes.
In the comfort of their home.
Yes, which is even better. So you have to make them available for them to inspect. If you have them on the website, that's even better. I have had people complain that they don't want to go find them on the website. I have not had that go to the court, but I am confident that if I went to a court and said, they asked for these minutes, we told them they're on the website, look, here they are on the website, a court would find that we had complied with our duty, our responsibility under right to know law. There are certain records that have to be made available, even though it seems like maybe they shouldn't be. For example, if you have an employee who resigns or is fired or retires, and you pay them anything above and beyond their regular salary and their accrued vacation, sick, or other leave, records of those additional payments have to be made available for public inspection without alteration immediately. Even if the matter has been considered or acted on in non-public session. Likewise, hang on, there's a likewise. Any settlement agreement, where is it? I can't find it. I'm going to get to it, and then I'm going to tell you the likewise. After the completion of a meeting, in addition to inspecting the minutes, people have the right to come and inspect any notes, materials, tapes, or sources you use to make those minutes. So in this day and age, most towns have a video recording. A lot of towns have audio we'll use to make the minutes from. RSA 33A, which is the Records Retention Act, requires that those materials be kept until the minutes are approved, and then you can delete them. If you don't delete them, those remain public records that people are allowed to come in and ask for copies of, and they get to review them even if you've retained them longer than you're required to retain them by statute. You have to keep all your governmental records at town hall. You can't keep them in someone's bathtub like we used to do in the old days. Records that are created in an electronic form have to be kept and maintained in their electronic form for the same archival period that 33A requires of paper records, and they have to remain accessible and available. So that means if you have them on microfiche and you no longer have a microfiche reader, you need to transfer them to some other form of, do you even know what microfiche is, Chris?
Yeah.
Okay. You have to transfer them to some other form of media that is now accessible and readable. And a government record in electronic form is no longer subject to disclosure once it has been actually deleted. Taking it from your inbox and moving it over to the deleted box does not count. When you empty that deleted box and no one at the town can then access it, including your IT people, then it is actually permanently deleted, and that is when it is no longer required to be disclosed. When anyone asks for a governmental record, if you have them immediately available, you have to provide them immediately. If they're not immediately available, you have 5 business days to either make the record available, deny the request, or provide a written statement telling them how long it's going to take you to come up with this document. So if someone comes in and asks for a tax card, you give it to them. If someone comes in and asks for 100 tax cards, you say, it's going to take me a couple of days. I'll get them for you in 5 days. If someone comes in and asks for 1,000 tax cards, within 5 days you send them a letter saying, it's going to take us about 30 days to get you those tax cards. If someone comes in and says, I want the personnel file of every single employee in town hall, then you're going to deny that request and you're going to tell them exactly why you're denying that request. And you have to tell them the specific exemption authorizing the withholding of the record and a brief explanation of how the exemption applies to the record withheld. And if you get that request, please, please, please call your lawyer and let us help you work your way through it. When the person requests copies, if you make the copy for them, you can charge them the actual cost of the copy. The change to the law this year, it used to be that you couldn't charge, and you can't charge the cost of searching. So if it takes your staff 100 hours to find whatever long lost document they're looking for, you cannot charge for that time. But you can start charging for electronic records. I think the decision has been made in Durham not to do this. But there is new authority to charge up to $1 per electronic communication, whether those are provided in hard copy or, but no charge can be incurred for the first 250 electronic communications, and certain requesters are exempt from being charged. And there's a very complicated way to count what constitutes a single electronic communication. So if anyone is interested in reading this fascinating legislation, it is House Bill 1002, and it is going to be an amendment to RSA 91A4. And I don't have the exact legislation with me. I have the guide from the New Hampshire Municipal Association that I know Todd also has, if anyone is interested in reading it. Other changes to 91A4 that were made this year that are really more common sense changes, and I think things we've all along anyway. There is now specific authority to reach out to whoever makes the right to know request and say, what are you actually looking for? Because I am happy to provide it to you, but you've asked me for 10,000 documents, and I feel like you're looking for something, and I'm happy to provide that to you. Help me narrow it down. Or, you've asked for every set of town council minutes ever. Do you really want that, or can you narrow that down for a specific time period? And so there's now specific authority to do that, and you can even make suggestions as to what might be helpful to both the town and the person making the request. In addition, there has also been, when we disclose records under the Right to Know law, we make an effort to redact personally identifying information. I tend to redact social security numbers, dates of birth, street addresses, telephone numbers, and places of birth, surprisingly, can be sensitive information. And I do my best to catch all that. Vehicle identification numbers, things like that. But I'm not perfect. And a lot of towns are starting to use AI to do that, and it's not perfect. So there is a new protection in the legislation that provides immunity from penalties in a civil action due to an inadvertent disclosure of information that would have been exempt from disclosure if the public agency makes a good faith effort to properly redact the documents but misses something. So that is nice to see in the legislation now. Here's the likewise. Every agreement to settle a lawsuit against a governmental unit, threatened lawsuit, or other claim entered into by a political subdivision or its insurance company has to be kept on file at the clerk's office and made available for public inspection for no less than 10 years from the date of settlement. So whenever the town settles a lawsuit, that settlement agreement is on file. And also important to remember that nothing in 91A requires the town to answer questions or compile documents or create a document or cross-reference a document. We have to produce a document we have. We don't have to make anything new up. So that is what we have to produce. What we don't have to produce is found in 91A5, which is the exemptions. And really the one that sort of everything hinges on is 91A5 Roman numeral 4, which are records pertaining to internal personnel practices, confidential commercial or financial information, examination data for employment, personnel files, library user files, and other files whose disclosure would constitute an invasion of privacy. This is not an easy thing to determine because it's not a straight test, it's a balancing test. And the balancing test is really hard to apply. You have to weigh the person's interest, privacy interest, versus the public's right to know, and decide whether the public's right to know what its government is up to outweighs the person's privacy interest. And that balance is really hard. The courts struggle with it. So how municipal officials are supposed to do it is beyond me. What I have had some towns start doing is filing declaratory judgment actions with the courts saying, we've had this right test. Here's our concern about the privacy interest. Here's what they're saying the public interest is. We don't think it's there. You, court, tell us what to do. Unfortunately, the last time one of my towns did this, the court said, not only do you have to disclose it, you should have known you had to disclose it, and now you have to pay the other side's attorney's fees. We were able to get that reversed on a motion for rehearing, but there is that risk. So I have been in contact with the New Hampshire Municipal Association suggesting that perhaps when the Right to Know Law Ombudsman office expires in 2025, perhaps it could be transformed into an office that could be advisory to towns and to citizens in such situations. Here's the records. You're an independent third party. Can you review them and tell us whether you think they need to be disclosed? And I think that would be extraordinarily helpful to everybody. So here's hoping. In the meantime, we struggle through. Records pertaining to matters relating to the preparation for and carrying out of emergency functions, categorically exempt. Unique people identification information collected in accordance with 193E5, categorically exempt. Notes or other materials made for personal use that do not have an official purpose, including but not limited to notes and materials made prior to, during, or after a governmental proceeding. If you're on a board and you're taking notes for your own personal use, throw them out. But B, if you don't throw them out, they're not subject to disclosure. Preliminary drafts, notes, and memos and other documents not in their final form and not disclosed, circulated, or available to a quorum or majority of the boards of the members. Once it's circulated, public document. Before it's circulated, not a public document. Body-worn camera footage from your police department, not subject to disclosure unless it shows restraint or use of force, discharge of a firearm, or a felony level offense. Then it is subject to disclosure. Records pertaining to information technology systems, including cybersecurity plans, categorically exempt, and records protected under the attorney-client privilege and the attorney work product doctrine. Right now are categorically exempt. There's some talk about subjecting those to the balancing test too, but we'll just put that aside for now and pretend that's not happening. Right now, until July 1st of 2025, if a citizen believes a town is violating the right to know law, they have two options. They can go to Superior Court, or they can go to the Right to Know Law Ombudsman, which is an office created in the hopes of simplifying and fast-tracking right to know law issues. It's sort of in the vein of the Board of Tax and Land Appeals for tax abatement cases, the Housing Appeals Board in land use cases. I haven't actually had any cases in front of the Right to Know Law Ombudsman. I know someone in our office has, and I think she has found it incredibly frustrating. So I don't know how successful it's being in any of its goals. I guess we'll see at the end of June next year whether it gets renewed or not. But basically, it's a very similar process at the Ombudsman as it would be in Superior Court. So you file your complaint, the Ombudsman or the court reviews your complaint and tells you whether or not you have violated the right to know law. The Ombudsman has some very strict timelines that the court does not have. We're going to focus on the court. So if the court finds that the town has violated the right to know law, the penalties can be pretty severe. First, if the town has violated the right to know law and the court finds that the town knew or should have known that it was a violation of the right to know law, and the courts are saying more often than not that the towns knew or should have known what they were doing was violating the right to know law, the court is going to find that the town is liable for the other side's attorney's fees, if they have an attorney. And you would be surprised how quickly those attorney's fees mount up. Or if the court finds that the violation was purposeful, which really is sort of the same thing. The court can award attorney's fees too if it finds that the lawsuit that was brought against the town was in bad faith, frivolous, unjust, vexatious, wanton, or oppressive. I have never seen that happen in 25 years. The court can also invalidate the action of the town if it was done in a meeting that was done in violation of the right to know law. So if it wasn't properly noticed, if it was not open to the public, if it was done in non-public where it shouldn't have been. So as a general rule, I get the following phone call the day after a meeting. So we did this last night, and I say, oh, you shouldn't have done that. And they say, okay. And I say, here's how we're going to fix it. And really, the only way to fix it is to properly notice a meeting and do it again. And if you do that, even if you get sued, all we can say to the court is, yeah, we violated the right to know law, but we recognized it, we called our attorney, we did everything we could to fix it, and we're really, really sorry. And courts are very receptive to that. So if you mess up, you've got to own it, you've got to fix it, but don't lose a tremendous amount of sleep over it, just don't do it again. Now, here's the real kicker. If the court finds that an individual has violated any provision of the right to know law in bad faith, it shall impose a civil penalty against that person of not less than $250 and not more than $2,000. In addition, if the town has been ordered to pay the other side's attorney's fees back up under paragraph 1, that individual now has to reimburse the town for those attorney's fees. And all that money gets, the penalty and those attorney's fees get paid back to the town. I've not seen that done. This is relatively new, and I'm showing my age when I say it's relatively new. It's probably 10 years old at this point. I've not seen this done, but it's there and it's severe. So it's really important that people understand and do their best to comply with the right to know law. And the other thing the court can do, and they do often, is enjoin of the right to know law and require remedial training. I have seen the remedial training required before. Generally, that's done by the New Hampshire Municipal Association, and it's actually surprisingly expensive. So we like to avoid that as well. One last goodie. A person is guilty of a misdemeanor if they knowingly destroy any information with the purpose to prevent that information from being disclosed under the right to know law. So there are civil penalties and there are criminal penalties for knowingly violating the right to know law. It's a lot of information. It can be overwhelming and it can be scary, but a lot of it's common sense. And you have a great staff here in Durham who is very familiar with the right to know law. If you have questions, if you have concerns, ask them, and they are going to lead you down the right road. And if you're a member of the public and you have questions or concerns, ask them. They're going to help you.
Just looking, Rachel, are there any questions on Zoom for Laura Spector?
No questions at this time.
Any questions in the audience?
Not for me.
So, I have a question.
Yeah.
Oh,
There was one other thing we were going to talk about.
Yes.
We were also going to talk about what to do. This doesn't have anything to do with the right to know law, but increasingly, not just in this town, I actually had this conversation this morning with another town. We're having issues with people who are disrupting meetings. They are standing up and they are speaking at times they're not supposed to speak, mean to the public body they are appearing in front of. They are loud, they are rude, they are disruptive, they are mean, they are disrespectful, and they are preventing the board from doing its job. And the question is, how do we address that? So it's very important that we remember we can never stop someone from talking based on what they're saying. However, someone who is disrupting the meeting to the point where the board cannot get its job done, we can have removed from the meeting. And I like to operate under a 3 strikes rule. You first say to the person, "Sir, it is not your time to speak," or "You have exceeded your allotted time to speak," or "What you're talking about is not germane to this board, and I need you to stop talking." And if they stop, wonderful. Or if they go sit down, wonderful. If they don't stop, or if they come back up 5 minutes later, you say, "Sir, you have exceeded your allotted time to speak," or "This is not your time to speak," or "What you're saying is not germane to this board. And if you continue to speak, I'm going to have to call the police because you're preventing this board from doing its job." If they continue, I would encourage the board to then take a break, call the Durham police, reconvene the meeting once the police arrive, and then if that person continues in that behavior, to ask the police to have that person removed from the meeting. They're gonna sue you, but as long as you have followed those steps and you are removing them because they are disrupting the meeting and not because they're calling board members criminals or making statements about people in the audience or policies they don't like, you're going to be okay. If it becomes an ongoing problem, there are ways to address it systematically. You can remove public comment from your meetings entirely. Public meetings are just that. The public has the right to attend. They don't have the right to speak unless it's a public hearing or unless you have a public comment section of your agenda. So if there's something going on that is particularly controversial, that is causing a stir, you can take public comment off your agenda for a period. You can set a time limit that people can only make public comment for 3 minutes or 5 minutes. You can move public comment to the end of the meeting. You can say people need to call and make an appointment if they want to address the board, and they have to be on the agenda, and there is no general public comment. You can say people can only speak during public comment about things that are not otherwise on the agenda that we're going to take public input on. So there are lots of ways to address it, but I think the most important thing to do is we hear all these nightmare scenarios about people being removed from meetings and towns getting sued and losing. And it's just really important to remember that that's not because they have the person removed from the meeting. It's because of why they have the person removed from the meeting. So if you have rules that you are applying fairly and consistently content neutral manner. And particularly in this day and age where everything is recorded and we have video proof that we can show the court, you're going to be okay. Does that make sense?
Mhm.
Any questions on that? Okay. Yes.
In terms of board members communicating by email,
Yes.
that's a challenge because so much of communication today is electronic.
Yes.
While board members can't have a dialogue on email, is it acceptable for a board member to forward information to the other members of the board? And that's all.
My preference, particularly in Durham, because you have such great staff, is if a board member finds information that they want to share with the rest of the board members, is share it with your staff person and ask that staff person to share it with the rest of the board members. If for whatever reason you don't have a staff person, then the only way to do it by email is to blind copy everyone and say, I found this and thought it would be interesting to discuss at our next meeting, period, the end. And by blind copying everyone, no one can reply to all and accidentally have a meeting.
Great, thank you.
Okay? Great.
Any other questions people might have?
We are always here to help, so ask Todd, and if Todd doesn't know, he'll send you our way.
Well, thank you for tuning in to this evening's annual Right to Know Law Forum. We appreciate it, and thank you, Laura Spector-Morgan, as always, for being here to
Thank you.
support our efforts. Thank you.
Good night.
Good night. This
Thank you, Rachel.
session is adjourned.